Start. Plaintiff has filed on record copy of demand notice issued to the defendant asking for payment of amount of rupees 5,32,836 and postal receipt and acknowledged receipt, and PW1 Jagdish has deposed about the same. As mentioned above, defendants have appeared in the suit and they are having knowledge about the claim of plaintiff against him about the transaction, however, not filed written statement and not denied the claim of plaintiff, and as discussed above, contents in the document wide exhibit 23 to 27 supports the claim of plaintiff and evidence of PW1 Jagdish and PW2 Amol, and so the evidence of plaintiff has remained unchallenged and unrebutted in spite of appearance in the suit and knowledge of the claim of the plaintiff against them. Defendants have not filed their written statement and not denied the claim of plaintiff, and so as adverse inference can be drawn against the defendants as per the provisions of section 114 of Indian Evidence Act. Para. As mentioned above, claim of plaintiff is supported by the above mentioned documents and it has remained unchallenged and unrebutted. So, from the above discussed entire evidence on record, plaintiff has proved that defendant has purchased goods worth of rupees 5,32,836 on credit from plaintiff. However, thereafter failed to pay the said bill amount, and an amount of rupees 5,32,836 was outstanding against dependents, and so dependents number 1 and 1A and 1B after the death of dependent Periaswamy are liable to pay the same to plaintiff. Hence, I answer point number 1 in the affirmative and point number 2 in the affirmative to the extent of outstanding amount of rupees 5,32,836. Plaintiff has prayed for recovery of outstanding bill amount with interest at the rate 24% per annum. The document of invoice dated 2/1/2017 shows that the rate of interest agreed between the parties for default of payment within 20 days is agreed at the rate of 24% per annum, and in spite of knowledge of said claim of plaintiff and appearance in the suit, defendants have not denied the same and not rebutted the evidence of plaintiff, and so in such circumstances and in the light of nature of transaction between the parties as commercial transaction, between plaintiff is entitled for the said interest rate as contractual rate of interest between the parties. Hence, I answer point number 3 in the affirmative.